Court is calling 2024 CR 009936, State versus Carrie Lampkin. Are you Carrie Lampkin? All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth, nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record.
Carrie Lanin.
All right, I'm going to ask you some questions, and the questions, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself, okay?
Qualified.
Hmm?
Qualified.
A what?
Qualified. To represent myself.
Yes. All right. So how far did you go into?
I'm in the family for right now. Should graduate next year now. Now getting behind the finals.
All right. So here's the thing. The best thing about being a witness and what attorneys always tell witnesses, just answer the question that's asked you.
Okay.
How far are you in school? All right. What year?
Sophomore last year.
All right. And what are you studying?
Yeah.
All right. And how many years have you studied the law?
I'm gonna say about 5 years.
All right.
So I was only in the civil litigation and family law.
So have you ever studied criminal law?
I never had it. Because I had to learn about it too. So now that I'm going through this.
All right. So remember what I said. Answer the question. Have you ever studied criminal law?
I've never studied criminal law. Most of my studies like all civil and
all right. So here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney. Do you understand?
yes.
All right. So do you want to have one? Can you afford an attorney?
Well,
That's yes or no?
Only no, because
All right. Then the next question, just listen to the questions. All right. Are you able to afford to hire an attorney?
yes.
Would you like an attorney appointed to you? That's either yes or no.
But I do have a speaker counsel, like, so working for my counsel to make a decision. I don't want to rush since yes and no, I don't.
No, I mean, here's the thing. You don't get a chance to choose who your attorney is. My question for you is, and I just want you to answer my question. Would you like to have an attorney appointed to represent you? That's either yes
No. I'm sorry. I just feel like I'm being pressured and rushed. I don't.
No, you're not being right. This case has been going on since January 2025. Let me explain something to you. When this case comes to trial, it is going to trial. There's not going to be at the last minute, I decided I don't want to do this. Let me get an attorney and get another recess. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any recess, because in the middle of the trial, you decide you're over your head and you need an attorney. That's not going to happen.
With all due respect, my attorney,
Here's the thing. Don't start with all due respect. Let me just tell you why. No. This is what I want to tell you. When people say with all due respect, they're really getting upset. And usually what comes after with all due respect is not with respect. It's like when people say, let me be honest with you. Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No problem.
I was to say with all respect, you know,
Right from the jump, this isn't your average court appearance. Carrie Lanin is not just here to answer charges. She's about to challenge the system itself. And the twist? She wants to represent herself against the state. Buckle up. This is about to get interesting.
With you from my attorney, there was an issue with discovery since day one.
Okay, here's the thing. I don't get into things about you and attorneys and what happened with your previous attorney unless your previous attorney is here to
Understand.
give their side of things.
So again, so I'm not affording my due process rights. I don't know. It's like it's like it's making decisions, and I don't.
It's not. It's either you want an attorney to represent you.
Be nice, Your Honor, if I could have some time to make a decision.
No,
Because I don't want to make the right decision if I'm going to do my shit. Already, the lack of the right of stuff.
my answer to you is no. If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial, and when you come in, it's going to trial. That's where we are. And I'm going to tell you again, previously when you were saying you were filing your bill of particulars, I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion, and if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just going to be denied. So it's not going to be my job to walk you through questioning of witness.
Hold up. She's actually a law student trying to represent herself in a criminal case. That's like learning to drive and immediately entering the Daytona 500. Judges see this all the time. People think knowing some law equals being ready for courtroom combat. Spoiler, it doesn't.
I'm assuming if this goes to trial, the state is going to call witnesses. It's not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence, criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects, and it is an appropriate objection, then it's going to be sustained.
Yeah.
So
legal advice or
you have been, though, because the motions that you've been filing have not been appropriate motions. Your bill of particulars, when I read it, it's really not a bill of particulars.
like I'm trying to be respectful as possible, and I'm applying pressure on me to make decisions. Everybody's moving faster. Like I don't consent to go to jury when I got my due process is violated. I'm praying that you can hear me out, but it seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you received that. And here's the thing, you're saying that's not true. But listen to me. Put on your listening ears. This is what I'm telling you. Your attorney, the attorney that you hired, your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney. That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you haven't received discovery. Your attorney says you have. So, nope, let me stop you there. So what I am telling you is this is going to trial, and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason.
So here's the big constitutional fork in the road. She has the right to an attorney, but she's hesitating. The judge can't force her to take one, but if she refuses, she'll be held to the same standard as a real lawyer. Would you risk representing yourself in a criminal trial?
Disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery. Their question, and this is the last time I'm going to ask it, and you can answer. If you don't want to answer, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer. Um, do you want an attorney appointed to you? Yes or no?
No pressure. I don't want.
All right, that'll be no. Ms. Ferguson, place this on the jury trial with Judge Angelini on June 16th.
I'm not going to talk. You know.
Sure. Talk. Go ahead.
So I have to one record, Your Honor. Substantiating evidence of that not been discovered. On May the 3rd, I received email of some more discovery that my attorney said. After I filed the motion to withdraw from it, the only reason why I filed this motion to withdraw from them is because of the lack of discovery. Since day one, you know it, man. Every time I came here, it was, oh, Your Honor, the files too big. Oh, Your Honor, no, I don't have, I haven't got it from this. Oh, Your Honor, he's had to come in and buy a hard drive. But he had his client, get a hard drive to go with it. And he still didn't give me a hard drive. You know, I have substantiated evidence to prove my time. And I have submitted it, I filed it in the clerk on the front. So if he's willing to say what he said, just record. If you simply discovery, I would love Your Honor if you could do a sworn.
The judge just dropped the hammer. When a judge says, this case is going to trial, that's not a suggestion. It means deadlines are over, excuses are done, and this train's leaving the station, with or without you. You can feel the tension building.
He's an officer of the court, so he doesn't have to do a sworn affidavit.
But I keep the burden. I showed the burden to Your Honor of my crimes. I'm showing you that I did not receive discovery till Saturday, 2 days before trial. 2 days before court. If you can look in the system, I created a statement signed by a notary that I signed under perjury, under sworn. I'm perjury. I'm not trying to go to jail over lying. I'm telling you, I'm not giving you discovery till on Saturday. That's Saturday before. And this is a job. And how could you that this shit's on the court? No, Your Honor, 1 month. 2 months out, 2 weeks after that. 1 month out. It's like he keeps yelling this stuff to me. Then he's saying the only policy. It's too late to make the decision to withdraw from counsel because he's not the best fit for me. Maybe other he's a good attorney. He's not probably to get into me. It's too late for him to represent myself. So I wanted to tell you. After I said, I went through 6 months reviewing with him, and I was very patient. I didn't say a word. I'm getting upset with him. He wanted me to treat him before I even got discovery. That's what really made me not upset, but made me concerned because I'm like, you representing me, but you want me to treat her without me having a discovery? Like, well, what if I due process right? You know, it's violation of my due process right. I need to be able to end myself. I cannot defend myself properly if I don't have all the evidence. Right? That's all I've been trying to say.
You're acknowledging discovery was signed, that discovery was received on April 14th. Ms. Ferguson, could you have somebody from the state come down, please? And if you'll give him a reset form for June 16th.
You're already denying the fact that we have to go into jury and have our due process for the rest.
I'm giving you extra time, that's why it's June.